The next bill up is House File 922, Representative Long. And Representative Long moves that House File 922 be referred to the Judiciary Committee. Representative Long, your bill is before us.
Thank you, Mr. Chair. Mr. Chair, when kids come into contact with the criminal justice system, we should do all we can to provide fair and appropriate treatment tailored to the individual and also set them up for long-term success. This bill contains 4 overdue common sense updates to our juvenile justice system. First, it prohibits shackling of youth making appearances in court unless a court finds there is need to prevent harm or flight. The humiliation and trauma of shackling a child can have long-term harmful effects. It also interferes with the presumption of innocence and raises due process concerns. The practice is opposed by the American Bar Association, by the National Council of Juvenile Court Judges, and more. This is a practice we should avoid whenever possible. Second, the bill removes the requirement for open hearings in certain juvenile proceedings. We should protect privacy for juveniles whenever possible when they are going through the court process. Third, the bill allows police officers to pursue alternatives to arrest for juvenile arrests. We know that many programs can be far more effective at rehabilitating youth than pursuing prosecution. This would open the door to police officers seeking better outcomes for youth they interact with. Fourth, the bill requires a risk assessment to be performed once youth are taken into custody to determine if it is necessary to detain the youth. Release for children while waiting trial is certainly preferable when possible, and the risk assessments will also consider if community-based supervision setting is appropriate. I want to thank Representative Novotny and Representative Mueller for their co-authorship and support of this bill. And Mr. Chair, we do have some testifiers to the bill.
Very well. I also want to acknowledge Representative Long, Representative Long. I also want to acknowledge Representative Ellison, our colleague here, who carried parts about all these provisions in the prior biennium. Representative Long, so we're going to move to your testifiers first, or are we moving to your author's amendment first?
As you prefer, Mr. Chair.
All right, well, why don't we do your author's amendment? So Representative Long moves to amend House File 922 with the A1 amendment. Representative Long.
Thank you, Mr. Chair. This is really a technical corrections amendment to get it in the shape that the author would prefer.
Very well. Representative Johnson, you okay with a voice vote on this?
Yes, I am.
Thank you, Representative Johnson. All in favor then of the, make sure I got the right number, A1 amendment, please say aye.
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 Aye. All same sign. Motion prevails. House File 922 as amended is before us. Representative Long will, I have 2 testifiers. I can call on them. Deputy Commissioner Curtis Shanklin and Director of the DOC Juvenile Justice Reform Unit, Katrina Dexter. And I believe we're starting with Deputy Commissioner Shanklin. Welcome to the committee, sir. Please state your name for the record and provide us with your testimony.
Thank you, Chair. Curtis Shanklin, Deputy Commissioner at the Department of Corrections, where I oversee our Reintegration and Restorative Services Division. Chair, members of the community, first and foremost, I hope you and your families are continuing to do well and stay healthy as we all continue to deal with the uncertainty of this global pandemic. I will provide a brief opening testimony followed by my colleague, Katrina Dexter. After testimony concludes, Katrina, myself, and Sarah Davis, who's the Executive Director at the Legal Rights Center, will be available for questions. Additionally, I know a number of community members have taken time to provide written testimony as well. When we talk about criminal justice reform and transformative change, it is important to note 2 elements that are vital to achieving either of these 2 aspirations. One being the usual elephant in the room, which is the racial and ethnic disparities that exist within the system. And the other being an intentional focus to ensure that youth are a part of these reform efforts and transformative change efforts, which is why we encourage our community members and criminal justice stakeholders, when they think about our justice-involved youth, to do that through the My Child test. So if your son or daughter, your granddaughter or grandson, your niece or nephew made a poor choice or was with a group of youth who made a poor choice, how would you want their treatment and their experience to be in the juvenile justice system? being a little presumptuous, but I would hope and garner that it would be to ensure that A, their needs are met, that they are appropriately held accountable, but more importantly, that they don't have any further contact with either the juvenile justice system or the criminal justice system in its entirety. And by using this My Child test, we begin to think about those kids as our kids. And when we start to think about those kids as our kids, then we're willing to work a little bit harder. I think we're willing to work with a little bit more of a sense of urgency. We're probably willing to go a little bit extra mile and maybe stay at work a little bit longer. We're willing to explore other alternatives, and we're willing to do so with a little bit more empathy, a little bit more grace, and a little bit more humanity. And we're willing to truly analyze how might historical trauma and victimization play a role in the choices that those youth have made today. Because the reality is, here in Minnesota, 75% of the kids that we arrest here in Minnesota are for our lesser persons of property crimes. They're not for the egregious homicides or first-degree assaults. Those Native American youth and American Indian kids who we arrest here in Minnesota and place in out-of-home placement are done so at rates that place Minnesota near the top in the nation when we talk about racial and ethnic disparities. Those Black and African American kids we arrest and place in secure detention after arrest, again, are done so at rates that place Minnesota at the top in the nation when we talk about racial and ethnic disparities. Those kids also in greater Minnesota who are dealing with chemical dependency and mental health issues that we continue to inappropriately use secure detention because our local law enforcement partners and members of the courtroom work group do not have the resources they need to appropriately address those needs. Those kids deserve better because those kids are our kids and we can do better. It's imperative that we do better, and we can do so right now. This juvenile justice legislative platform provides us that opportunity, an opportunity to really show Minnesotans that even in a divided legislature, we can come together across party lines and get meaningful work accomplished, that the needs of our youth transcend party lines, and it has. And I think that's evident in the bipartisan support of these two bills. Katrina and myself have met with almost every member of this committee, and we have had the honor to present before the bipartisan caucus early this week at the invite of Representative Poston and Representative Long, because they have made juvenile justice reform a top priority and see how it crosses party lines. That is also evident, as the chair pointed out, in Representative Novotny and Representative Mueller offer their support to these bills as well, because our kids mean that much. Their futures mean that much, but more importantly, their lives mean that much. And I cannot think of a more important issue that deserves our urgent attention than the lives of our future leaders of tomorrow. And every day that goes by that we don't act with a sense of urgency, that we don't act with determination, with intentionality, is a day that ultimately we don't show that we love those kids as our kids, is a day that we don't believe in those kids as we do our kids, is the day that we ultimately don't value those kids as we do our kids. And to put it frankly, that is not one Minnesota. With that, I'll conclude my testimony today here, Chair, and I'll be open for questions that follows, and I'll pass it on to my colleague, Katrina Dexter, the Director of our Juvenile Justice Reform Unit.
Thank you, Mr. Shanklin. Always good to have you, Deputy Commissioner, in our committee. Thank you for your eloquent words and powerful call for us to truly embrace and love all our young people in Minnesota. You did reference that there were several letters. I just want to quickly call out, there was a letter in the record from 10th grader Eric Lee, or Lai, Eric L.I., with Minnesota Youth Council, and also Paula Akakpo with the Minnesota Youth Council, an 11th grader, in addition to a letter from the Youth Prize. Incidentally, my son, maybe at the very beginning of Youth Prize, was on the founding board as a high school student back then. So that's a letter from Matt Norris, and then a letter from Beth Holger from the Lake. So thank you for sending that testimony in to us. With that, Ms. Katrina Dexter, Director of DOC Juvenile Justice Reform Unit. If you come forward, state your name for the record and provide us with your testimony, we'd appreciate it.
Mr. Chair and members of the committee, thank you for the opportunity to testify regarding this important legislation today. My name is Katrina Dexter. I'm the Director of Juvenile Justice Reform at the Department of Corrections. Today, I'm here to testify on House Files 922 and 947. First and foremost, I want to thank each of you who took the time to meet with myself and Deputy Commissioner Shanklin to discuss these important policies preceding this committee hearing, as well as the members, both Republican and Democrat, who have already signed on to author these bills. Following the agenda of the committee, I will present at 2 separate times and keep my testimony specific to the bills before us. However, I want to frame my testimony in the understanding of what these 2 bills and the provisions within were built upon, which is what we know is best practice in juvenile justice, as well as the expansive research we have on adolescent brain development. With that being said, I will transition to speaking to the provisions of the current bill and will keep my testimony limited as I know we have a full agenda. The bill before us now is House File 922, and as previously stated, is co-authored by Representative Long and Representative Novotny. There are 4 sections or provisions to this bill, and I will begin with the section 1, which is intended to end the indiscriminate use of restraints during juvenile court proceedings. A few examples of restraints used here in Minnesota include handcuffs, ankle shackles, as well as belly belts. Currently in Minnesota, if a youth comes through the detention or placement doors to court, the presumption is the youth will be detained and shackled or restrained during that court proceeding. This provision would change the presumption for no longer restraining youth in court. However, any stakeholder involved in the case can request that the youth be restrained. For example, if the detention facility staff or court security staff believe there is a security threat or a risk of flight, they can make a request that the youth be restrained. Those requests would be decided on a case-by-case basis by the presiding juvenile court judge. We work closely with the Minnesota Sheriff's Association specific to this section and have limited the change to the courtroom. As a result, transport is not included. The second section of this bill is regarding public hearings for 16 or 17-year-olds. Currently, if a youth is alleged to have committed a felony level offense, their court hearings are open to the public. This provision would close those court hearings. However, we have included an exception for cases classified under extended jurisdiction juvenile or EJJ status. It is important as we make advances in technology that we understand the potential collateral consequences that may come from those advancements. As an example, if a youth court hearing is open to the public, a local reporter could attend that court hearing and publish the details of the case, including a youth's name in the local newspaper. Subsequently, that case could be dismissed, or maybe the youth is never found guilty. However, unfortunately, that newspaper article with the youth's name may live on forever on the internet and will only be a Google search away. This section attempts to limit that collateral consequence. The third provision in this bill will provide explicit statutory authority to our local law enforcement, both police departments and sheriff's offices, to defer youth to programming. This is currently already allowed under Minnesota law, which is why many of our local law enforcement agencies are already doing this great work, some formally and many others informally. In hearing the need from local officials that explicit statutory authority would allow them to formalize and potentially expand their already great work, this is exactly what this section is attempting to accomplish. The final section in this bill, section 4, would require that secure detention facilities in the state of Minnesota use an objective and racially, ethically, and gender responsive juvenile detention risk assessment instrument, also known as ARRAY, to inform detention decisions. Under the JDAI, or the Juvenile Detention Alternative Initiative model, many secure detention facilities, both in Minnesota as well as nationally, use such tools. The ARRAY is specific to the first 36-hour window of time from the potential decision to detain to the required court hearing, and it specifically assesses a youth's risk to endanger others or not appear for the court hearing. Lastly, I will point out that some states, like Wisconsin, use one tool for the whole state, regardless of the location. We are asking that here in Minnesota, and listening to our local stakeholders and understanding the very different locations of our secure detention facilities in this state, we are asking that those facilities use a model of the ARRAY and tailor it to their local jurisdiction. This will allow local jurisdictions to tailor it to their local resources, as well as allow all local stakeholders to be involved in the creation and implementation of their RAY tool. This concludes my testimony on House File 922, Mr. Chair, and I will be available for questions. Thank you.
Thank you, Director Dexter. We do have a couple of questions. We have Representative Lucero, followed by Representative O'Neill. Representative Lucero. I think you're muted, Representative Lucero. Not quite. Oh, there we go.
Can you hear me? Yes, no?
You're good.
You're good. Okay, cool. Thank you. I apologize for that. Thank you, Mr. Chair. Thank you to the bill author. Thank you to the testifiers. I just sent an email, Representative Long, to be added on as a co-author on this. While I have concerns over that last provision in Section 4 regarding the risk assessment, it doesn't override my interest in the other provisions. And the reason being, Section 1, as we discussed, as the representatives from the department discussed, the broken window, or not the broken windows theory, the labeling theory can have a huge impact. And to have somebody in shackles can and often does create a certain perspective, and we definitely want to remove that perspective. And then in Section 2, in regards to closing the hearings, you know, many of the things, as we also discussed, and Mr. Chair, actually, we discussed in a meeting, many of the differences between those that are, unfortunately caught up in the juvenile justice system and myself is they got caught, I didn't. I haven't done many of the same things, many of the same mistakes. And when it comes to things living on forever, I am so happy that social media didn't exist when I was in middle school or high school, because the stuff that goes on, and we all know, even into our early 20s, and for some beyond, but we don't have the life experience, we don't have the filter of the decision-making that we would share onto social media, making the stuff available that can come back to haunt us in our 30s and beyond. And certainly things like this, we all know at that age, there's a huge difference in maturity level, and people can and often do change. That I would not want mistakes made when somebody's a juvenile to go on and haunt them forever. For sure, that is not the case. So I do support those provisions. Again, I just, unfortunately, the words, some of these words in the risk assessment have a polarizing impact. For example, I'm not exactly sure what gender responsive risk assessment even means, but nevertheless, there are some important provisions, and I appreciate that this important conversation is continuing to move forward. So thank you, Mr. Chair and Representative Long.
Thank you, Representative Lucero. Representative O'Neill.
Thank you, Mr. Chair. I just have a quick question for the bill author. Just something I think is really important to get on the record because it was spoken of very quickly. So you were talking about basically a diversion program where law enforcement officers could divert directly and avoid court. But I think it's really important to say which offenses are included in that, because and maybe you touched on it, but I just think that's really important if we're going to, and maybe court is involved at some point, I'm not sure, but the way it was described, and I was just trying to read through the bill, but if you could just clarify on the record which offenses actually qualify for this diversion program so that it's not everything under the sun.
Representative Long.
Thank you, Representative O'Neill, for the question. So you're correct. It's not for all circumstances. The alternatives to arrest would not apply, for example, if peace officers were pursuing an order or warrant, or if there was an order to take the child into custody. But for other circumstances, when the peace officer may be arresting the individual, they could seek to, rather than pursue prosecution, they could seek to find an alternative to arrest, a program that they're familiar with that they think would help the child get on a better track than seeking prosecution.
Mr. Chair. Mr. Chair, just a really quick comment back, because I was hoping he was actually going to pull out the language of the bill, which says petty offenses and delinquency. And I think it's important to realize really that this is very, very narrow, because you're giving law enforcement the ability to basically avoid court. So we have to be very clear what we're doing, kind of like issuing a traffic ticket. So we have some diversion programs that do something like that. So I just wanted to make very clear which offenses were allowed to be diverted this way.
And Deputy Commissioner Shanklin, you spoke a little bit about, to this issue, I think. I think you've got some comments to make.
Thank you, Chair. What I was going to say is that I think my colleague, who is also available for questions, who's done a lot of work on this side, Ms. Sarah Davis, Executive Director at the Legal Rights Center, if she's willing to, I think, can speak directly to the representative's question.
Ms. Davis, welcome to the committee. If you could, I hope you heard the question, and if you could be as concise as possible, the chair would certainly appreciate it, but welcome to the committee. Please state your name for the record.
Thank you, Mr. Chair. Sarah Davis, Executive Director at the Legal Rights Center. Mr. Chair, Representative O'Neill, and members, you know, the way that the provision is drafted, it essentially is just recognizing the inherent authority of police departments to do this already. So let me just give you an example. It's happening for, you know, for example, we've worked with the Minneapolis Police Department for many years. No, you know, they're not diverting, you know, high-level felony cases, things like that. They divert cases that otherwise would be cited. So I think Representative Long talked about the exceptions here. For example, if there's a warrant or other circumstances like that. So, you know, I guess I'm reading into the question that there's a concern about the seriousness of the offenses. And I think there's this, you know, there's an inherent authority for police to make choices all the time when they have cases before them. And this is happening in some communities and not in others. And what we're trying to avoid is a justice by geography situation where kids in Minneapolis have access for, you know, diversion by the police department, but a kid in another city in our state might not have, you know, but I'm just going to use Rochester. I have no idea if they do that or not, but I'm just picking a name, might not have that opportunity. And what we know is that by doing this, the police departments who do this save a lot of money and reduce recidivism rates for kids who have the opportunity to go through diversion. And so there are exceptions, as Representative Long pointed out, and it's not my experience that any police department is doing this for serious felony cases.
Well, it does seem to me, Ms. Davis, that particularly in this day and age where there's a heightened attention to our law enforcement professionals, and rightfully so, that one of the, I think, hopeful postures of this language is that we really are counting to a large degree on peace officers to exercise good professional judgment here. And I think that is the kind of work that I would argue that we want to be able to nurture and encourage, you know, from our law enforcement officers. Representative Johnson.
Mr. Chair, may I just?
Oh, yes. Representative.
I'm sorry. I'm trying to make this easier, not harder. I'm not trying to point out something that's wrong. I'm just trying to clarify. And the language literally says both petty offenders and delinquents are eligible for referral under this section. So I'm just trying to be clear that we're talking about low-level petty offenses and delinquency and not anything above that. So I was trying to get that clearly on the record. Yep. So there were no concerns. I was hoping for a really quick answer from Representative Long, but unfortunately we kind of went around, but that's all I was trying to get at.
Well, I appreciate you getting it on the record, Representative O'Neill. Representative Johnson.
Chair Mariani, members, there's some good things in this bill. Some of it I agree with, doing the risk assessments. Anytime anybody's brought into the system for detention, there should be a risk assessment to make sure they're in the right place where they need to be for the safety of the public and for the safety of them. Now, with the issues of restraints in the courts, court rules already apply on that. And this is just codifying those rules. It's been the last 2/3 of my career in law enforcement. Unless we could actually prove to the judge that there was a need, juveniles were never restrained in our courtrooms. I don't know if that's different in other places, and it should be a standard everywhere. where, especially with the kids, that they're not restrained unless they need to be. But the judges understand and they take everything into account. And there's been times that where I was in the courtroom where a juvenile, we wanted to restrain because we knew what he was like. The judge said no, and we ended up having a issue in the courtroom because he was not restrained. He went after the judge. So law enforcement generally knows when they need to restrain somebody and when they don't, and judges are good at it as well. Now, the second section, I believe it is about the records and having access to open up the juvenile courts a little bit. Over the past few years, the legislature has looked at opening instead of closing. And this could actually be a step backwards because the judges are well equipped to making a judgment, weighing the difference and the balancing the needs of the child and the safety of the public. I know we want to make sure that the child is taken care of properly, but we also have a duty to the safety of the public, depending on the circumstances of the case. And that's where the judges are well equipped to handle that. One thing was brought up about the diversion. I don't know what happens down in Minneapolis. I know what happened in my community until the policy manuals got to the point where we could no longer do that. When I started, my policy manual was about 30 pages. Now it's close to 700. If you want to compare, the Bible is around 1,200 pages. And if we followed the Bible, we wouldn't probably need any of us to be here because we wouldn't be dealing with this stuff. But that's another story. But unfortunately, the policies for law enforcement have gotten so strict, they can't do things they used to do. They used to use officer discretion. I don't know how many times I've caught a kid or a group of kids doing some mischief. I could have wrote them up, got them into the system, but I didn't do that. We worked with the parents, and the parents brought them down to the fire hall to wash all the fire trucks before the parade. We'd find things to do to make them learn and give them an experience to know what is right and what's wrong. And we know kids are going to make mistakes. They're always going to push the rules as far as they can. Sometimes they go too far. But we learned that working with the parents, we can keep them out of the system. Now, we do a diversion program. There's always going to be a record. No matter how hard you try to seal it, there is going to be a record. So I just want to make sure that I agree with the most of the stuff in this bill. I'm going to support it at this time. But we need to look at a better way to do this instead of even getting into a system where they're into a diversion system where there's a documentation of it. We need to make sure that we're working with the parents to make sure the parents are doing the right thing as well. And I've learned that some parents will help, some won't. Those that won't help, chances are we're going to be dealing with those kids again. And the parents that worked with us, I know 3 of those kids that are now police officers, but because we were able to do the diversion on our own before they even got in the system, they were able to turn their lives around and they're good, productive citizens today. Thank you.
Thank you, Representative Johnson. Much work will continue, will be needed, even assuming this bill becomes law. Representative Long, I'm going to move you because we got to move. Representative Long renews his motion that House File 922 as amended be referred to the Judiciary Committee. The clerk will take the roll.
Chair Mariani.
Aye.
Chair Mariani, aye. Vice Chair Frazier.
Aye.
Vice Chair Frazier, aye. Representative Johnson.
Aye.
Representative Johnson, aye. Representative Edelson.
Aye.
Representative Edelson, aye. Representative Feist.
Aye.
Representative Feist, aye. Representative Grossel.
Aye.
Representative Grossel, aye. Representative Hollins.
Aye.
Representative Hollins, aye. Representative Hewitt.
Aye.
Representative Hewitt, aye. Representative Cleaborn.
She was excused to testify, I believe.
Oh, okay, thank you. Representative Long.
Aye.
Representative Long, aye. Representative Lucero.
Yes.
Representative Lucero, aye. Representative Mueller.
Mueller votes yes.
Representative Mueller, aye. Representative Novotny.
Novotny, aye.
Representative Novotny, aye. Representative O'Neill.
O'Neill, aye.
Representative O'Neill, aye. Representative Pinto.
Aye.
Representative Pinto, aye. Representative Poston.
Poston, aye.
Representative Poston, aye. Representative Raleigh.
Raleigh, aye.
Representative Raleigh, aye. Representative Vang.
Vang, aye.
Representative Vang, aye. Representative Zhang.
Aye.
Representative Zhang, aye. That concludes roll call with 18 ayes and 1 excuse.
Very well. On a vote of 18 ayes with 1 excuse, House File 922 as amended is referred to the Judiciary Committee. Thank you, Representative Long, and thank you, Representative Novotny, as a co-author on this bill as well.